the only peaceful solution. We in America do not have government by the majority. We have government by the majority who participate. Thomas Jefferson. Today we have a constitutional crisis. We have a judicial crisis. We have a political crisis. We have an economic crisis. Add to that a national emergency, and we've come to the end of America. If you fail to act today, this will be America's children. Silence and non-action equal consent. In 1 Chronicles chapter 28, verse 20, we read, "Be strong and of good courage, and do it. Fear not, nor be dismayed. For the Lord God, even my God, will be with thee. He will not fail thee, nor forsake thee, until thou hast finished all the work for the service of the house of the Lord." Power. It's all about power. Today the elite control the people through legislation, corporations, monopolies. They control the government through parties. They control our judicial process through the Bar Association. They control our education. They control our entertainment. They control our media. They control our religion. And they control our money. And all this adds up to the New World Order. The solution. Establish 3,133 common law grand juries in all 3,133 United States counties. It is the duty of the common law grand jury to expose all fraud and corruption, whether it be in the political or the judicial realm, and stop it. The authority of the grand jury is found only in the Bill of Rights. Therefore it comes from God and not government. Fifth Amendment. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or an indictment of a grand jury. A presentment differs from an indictment in that it is an accusation made by a grand jury of its own motion, either upon their own observation and knowledge or upon evidence before them, while an indictment is preferred at the suit of the government and is usually framed in the first instance by the prosecuting officer of the government, and by him laid before the grand jury to be found or ignored. People v. Forster. The following is from a U.S. Supreme Court ruling, United States v. Williams. Anton Scalia, writing for the majority, said, "It is a constitutional fixture in its own right. The American grand jury is neither part of the judicial, executive, nor legislative branches of government, but instead belongs to the people. It is in effect a fourth branch of the government, governed and administered to directly by and on behalf of the American people, and its authority emanates from the Bill of Rights. The Fifth Amendment demands a traditional, functional, common law grand jury. The grand jury is an institution separate from the courts. The courts do not preside over the functioning of the common law grand jury. The courts have no supervisory judicial authority over the common law grand jury. The grand jury's functional independence from the judicial branch is evident, both in the scope of its power to investigate criminal wrongdoing and in the manner in which that power is exercised. The grand jury can investigate merely on suspicion that a law is being violated, or even because it wants assurance that it is not. The grand jury need not identify the offenders, its suspects, or even the precise nature of the offense it is investigating. The grand jury requires no authorization from its constituting courts to initiate an investigation or to seek an indictment. The grand jury operates without the interference of a presiding judge. The grand jury swears in its own witnesses and deliberates in total secrecy. The grand jury remains free to pursue its investigations, unhindered by external influences or supervision, so long as it does not trench upon the legitimate rights of any witnesses called before it. The Fifth Amendment's constitutional guarantee presupposes an investigative body acting independently or either prosecuting attorney or judge. The grand jury belongs to no branch of the institutional government, serving as a kind of a buffer or referee between the government and the people. The Sixth Amendment right to counsel does not attach when an individual is summoned to appear before a grand jury, even if he is the subject of the investigation. It would run counter to the whole history of the grand jury institution to permit an indictment to be challenged on the ground that there was incompetence or inadequate evidence before the grand jury. What's possible? We can turn back the political and judicial clock to 1789. We can indict criminals, including judges and politicians. We can reinstate the real duties of the sheriff. We can reinstate the elected committeemen. We can reopen our armories and reinstate our militias. We can force compliance to the Third Continental Congress 2009's Article of Freedom. We can stop open political corruption and bind them by the chains of the Constitution. We can stop open judicial corruption and bind them by the chains of the Constitution. We can do all of the above in 30 days or less. We can save America. Jurisdiction. No person can be tried for a crime without an indictment by a grand jury of their peers, and if indicted, they are to be judged by a jury of their peers. In suits where the value in controversy shall exceed $20, the right of the trial by jury is preserved. No decision of a grand jury is reviewable in any court of the government. Any government transgression and against anyone in any respect. Any government breaking of articles of peace or security. Any dispute regarding anyone who has been unconstitutionally detained or removed by the government without legal sentence of his peers from his lands, his homes, his liberty, or lawful right. The jury rules. It is the duty of the grand jury, if anyone's unalienable rights have been violated or removed without a legal sentence of their peers from their lands, homes, liberties, or lawful rights, we, the 25, shall straightway restore them. And if a dispute shall arise concerning this matter, it shall be settled according to the judgment of the 25 grand jurors, the sureties of the peace. Marbury versus Madison, a legal maxim. Every right, when withheld, must have a remedy, and every injury its proper redress. Hoke versus Hankinson. That statute which would deprive the citizen of the rights of a people of person or property without a regular trial according to the course and usage of common law would not be the law of the land. There is a common law principle which states that for there to be a crime there must first be a victim, corpus delicti. In the absence of a victim there can be no crime. The state cannot be that victim. In order to establish justice, ensure domestic tranquility, secure the blessings of liberty to ourselves and our posterity, by deliberating under natural law, principled under justice, honor, and mercy, for a perpetual administration of trust on behalf of the people, acknowledging the foundation upon which all law weighs. The common law grand jury can and will take control. We will read the Riot Act to all our elected and selected Supreme Court judges. Prosecutors, no more puppet grand juries and jurors. We will end corruption in our state capitals. Sheriffs are the people's police force, and are the top cop. They must keep their oaths and disobey any illegal orders, and we will back them up. Common law grand jury indictments cannot be stopped. The process. Grand juries issue a true bill, an indictment. True bills are signed by the grand jury foreman. Indictments are filed with the clerk of court, thus beginning a formal criminal proceeding. U.S. 18-2071. Whoever willfully and unlawfully conceals, removes, mutilates, obliterates, or destroys or attempts to do so, documents filed or deposited with the clerk or officer of any court shall be fined or imprisonment not more than 3 years, or both. U.S. 18-2076. Clerk is to file. Whoever being a clerk willfully refuses or neglects to make a forward or any report, certificate, statement, or document as required by law shall be fined under this title or imprisoned not more than 1 year, or both. And this one is very specifically for the judge. 18-1512b. Whoever knowingly uses intimidation, threatens, or corruptly persuades another person to or attempts to do so, or engages in misleading conduct towards another person with the intent to influence, delay, or prevent an official proceeding, causes or induce any person to withhold a document or other object from an official proceeding, alter, destroy, mutilate, or conceal an official proceeding, shall be fined under this title or imprisoned not more than 20 years, or both. We have been conditioned. We have been robbed. If you have a spiritual problem, we have been taught to find a priest or a pastor. If you have a political problem, we have been taught to join a political party. If you have a justice problem, you have been taught to hire a lawyer. We have been taught to become a slave. Spiritual power is forgiveness of sins, unalienable rights, a sense of justice, a sense of honor, a sense of mercy. Political power provides for domestic tranquility, common defense, and general welfare. Judicial power establishes justice and secures the blessings of liberty. By these three, a man controls their destiny and frees themselves from tyrants. Until you control all three powers, you cannot have liberty. 2 Chronicles chapter 7, verse 14. If my people, which are called by my name, shall humble themselves and pray, and seek my face, and turn from their wicked ways, then will I hear from heaven, and will forgive their sins, and will heal their land. The judicial fraud. Our courts are controlled by a private association. The state does not license lawyers. Furthermore, lawyers do not practice law. They practice statutes, which are not the law. The state bar card is not a license. It is a union dues card. The bar is a professional association like the actors' union, painters' union, etc. No other institution, even doctors, issue their own licenses. All licenses are issued by the state. The Bar Association is a private association. It cannot license anyone on behalf of the state. The ABA accredits all the law schools, holds their private examinations, selects the students they will accept in their organizations, and issues them so-called licenses for a fee, but does not issue state licenses to lawyers. The bar is the only one that can punish or disbar a lawyer, and not the state. The ABA also selects the lawyers that they consider qualified for judgeship and various other offices in the state. Only the Bar Association or their designated committees can remove any of these lawyers from public office. Beauvair's Law Dictionary tells us that justice is synonymous with virtue. It is confined to things simply good or evil. Luke chapter 6 verse 19 tells us virtue emanates from God. History records the struggle in courts between the mind of God and the mind of men, civil law versus common law. In Luke 11:52, the Lord said, "Woe unto you lawyers, for you have taken away the key of knowledge, and God is that key." Right to practice law. Lawyers and attorneys are not licensed to practice law. The certificate from the state Supreme Court only authorizes them to represent wards of the court. Davis Committee versus Looney. Wards of the court are infants and persons of unsound mind, someone placed under the protection of a legal guardian by the court. A next friend is a person who represents someone who is unable to tend to his or her own interests. Federal Rules of Procedure. The practice of law cannot be licensed by any state. Schwer versus Board of Examiners. The practice of law is an occupation of common right. Sims versus Aarons. Members of a group who are competent non-lawyers can assist other members of the group achieve their goals of the group in a court without being charged with unauthorized practice of law. NAACP versus Button. Statutes are not law. Our courts are controlled by a private association. Legislators are authorized under the Constitution, ordained by the people, to write statutes and code enforcement as law to control bureaucrats, municipalities, government agencies, elected officials, interstate commerce, but not the people, whose rights are unalienable and cannot be legislated. The common law is the real law, the supreme law of the land. The codes, the rules, regulations, policies, and statutes are not the law. Self versus Ray. The general rule is that an unconstitutional statute, though having the form and name of law, is in reality no law, but is wholly void and ineffective for any purpose, since its unconstitutionality dates from the time of its enactment. In legal contemplation, it is as inoperative as if it had never been passed. Since the unconstitutional law is void, the general principle follows that it imposes no duties, it confers no rights, it creates no office, it bestows no power or authority on anyone, it affords no protection, and justifies no acts performed under it. A void act cannot be legally consistent with a valid one. An unconstitutional law cannot operate or supersede any existing law. Indeed, insofar as the statute runs counter to the fundamental law of the land, the Constitution, it is superseded thereby. No one is bound to obey an unconstitutional law, and no courts are bound to enforce it. Bonnet versus Valia. It's all about jurisdiction and consent. Challenge jurisdiction, and you will win. To deprive the people of their sovereignty, it is first necessary to get the people to agree to submit to the authority of the entity they have created. This is done by getting them to claim they are citizens of that entity. If defendants enter a plea of not guilty and is in the court the day of the trial, the court has jurisdiction over the person. States versus Waters. Municipal courts do not have jurisdiction to render final judgments on felony charges. Mohammed versus State. Appearance tickets is not accusatory instrument, and filing does not confer jurisdiction over the defendant. People versus Gabay. Service of an appearance ticket on an accused does not confer personal or subject matter jurisdiction upon a criminal court. People versus Gusty. Trial courts act without jurisdiction. when it acts without inherent or common law authority. State versus Rodriguez. When challenged, jurisdiction must be documented, shown, and proven to lawfully exist before a case may lawfully proceed in the court. Basso versus UPL. Where the court is without jurisdiction, it has no authority to do anything other than to dismiss the case. Fortunat versus State. Criminal law magistrates have no power of their own and are unable to enforce any ruling. Davis versus State. Every man is independent of all laws except those prescribed by nature. He is not bound by any institutions formed by his fellow man without his consent. Trudent versus Neal. Law is not complex. Common law is natural law, written in the hearts of all men. Matthew 22, verses 37 through 40. Love the Lord thy God with all thy heart, and with all thy soul, and with all thy mind. This is the first and great commandment, and the second is like unto it. Thou shalt love thy neighbor as thyself. On these two commandments hang all the laws and the prophets. The law is written in the hearts of men. Romans 2:15. Natural law. If there is no injured party, there is no crime. Principles of liberty, consent and jurisdiction. It's all about consent and jurisdiction. In order to have liberty, it is extremely important that you understand consent. Our servant government can do nothing without your consent. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights governments are instituted among men, deriving their just powers from the consent of the governed. Declaration of Independence. And the governed consent through juries. The government can do nothing to anyone without the consent of the people, either by grand jury or trial jury. Any authority our servants have is by our consent. If they act outside their authority, they are subject to the criminal charges under U.S. Code 42 and 18, and liable for all damages under U.S. codes and common law. Our servant government has defrauded us. They know they need the people's consent, but they dumbed us down and created facades. The existing grand juries are puppets controlled by the politically appointed government, paid prosecutors who orchestrate the will of the grand jury. The existing trial juries are puppets controlled by the government-paid judges under political pressure to maintain the status quo, who orchestrates the will of the trial jury. They know they need the people's consent, and they commit fraud every time they use the puppet juries, and now you know. The judge is your servant. He has no authority to judge and sentence you without your consent. In legal terms, when the judge asks you, "Do you understand?" he means, "Do you stand under the authority of this court?" So when you say yes, you just gave him or her jurisdiction over you. Our U.S. Constitution only authorizes common law courts. Our New York State Constitution says, "The courts of appeal, the Supreme Courts, including the appellate divisions, shall be courts of record." A court of record removes the power of the judge to making a ruling. His role is that of an administrator of the court. The final determiner is the tribunal, who is either the sovereign plaintiff or the jury. Remember, the servant cannot rule over the master. Can the clay rule over the potter? Our servant government has defrauded us. They know they need the people's consent, but they dumbed us down and created facades. The existing grand juries are puppets controlled by politically appointed government-paid prosecutors who orchestrate the will of the grand jury. Every man is independent of all laws except those prescribed by nature. He is not bound by any institution formed by his fellow man without his consent. Cruden versus Neal. Herein is liberty. If you do not give them consent, they have no jurisdiction over you. So under U.S. Codes 42 and 18, when you are detained for violating a statute, you have just been kidnapped. And if the judge sets a bail, he set a ransom. And when the prosecutor confirms the charges, they're all part of a conspiracy, and you can put them all in jail and receive compensation for your injuries. It's all about consent and jurisdiction. Find out more, nationalliberyalliance.org. National Liberty Alliance's plan. Thomas Jefferson said, "An enlightened citizenry is indispensable for the proper functioning of a republic. Self-government is not possible unless the citizens are educated sufficiently to enable them to exercise oversight. It is therefore imperative that the nation see to it that a suitable education be provided for all its citizens." The purpose of National Liberty Alliance is to facilitate the organization, communications, and education for the administration of common law grand juries across the nation. Declaration. We, the people of the United States of America, by the mercy and grace of God, having blessed the people with the unalienable right of self-rule, by impaneling juries secured by the 5th, 6th, and 7th Amendment of the Bill of Rights for the United States of America, in order to establish justice, ensure domestic tranquility, secure the blessings of liberty to ourselves and our posterity, by the securing of natural law, do ordain and reestablish common law grand juries, principled upon justice, honor, and grace, for a perpetual administration of trust on behalf of the people. Organization. National Liberty Alliance has assisted the people in all 50 states to establish a leadership and unify every county in the state by the reconstituting of the common law grand juries. This was accomplished by press releases in each county inviting the people of each county to come together to agree and declare a return to the common law juries. We are still helping to establish leadership, membership, and administrators in every county. On February 27, 2014, New York constituted all of its 62 counties, thereby becoming unified. On August 27, 2014, Iowa, the 50th state, also constituted all of its 92 counties, thereby becoming unified. And in doing so, all 50 states now have become unified as the unified United States common law grand jury. Communications. National Liberty Alliance sponsors weekly national conference calls to provide updates, open forums, instructions, and encourages each state to have weekly telephone meetings. Education. NLA offers a free civics course covering American history, 28 great ideas that changed the world, U.S. Constitution, common law, trial by jury, how America lost her way, individualism versus collectivism, and our Founding Fathers' convictions concerning religious principles, political precepts, economic fundamentals, and long-range social goals. Training. National Liberty Alliance provides on-the-job training for the administration of the juries. We are now training people to fill 4 administrators' positions full-time for each county. All positions are on-the-job training, and NLA's free civics course is required for the position of administrator at nationalliberyalliance.org/civics course. We are seeking to fill approximately 18,000 positions in approximately 3,100 counties. Salaries range from $45,000 to $156,000, calculated by experience. For administrators, We have established from the Magna Carta, paragraph 61, that there must be a minimum of 4 administrators per county. More may be required for the more densely populated counties, and 1 skilled legal secretary per county. Principles and maxims. Administrators will not establish rules, nor will there be any chairman, but will be ruled by a vow to God, thereby adhering to 3 principles and 2 maxims. Anyone who acts outside of the principles are in dishonor, and must correct themselves or resign. It is the duty of the other 3 administrators to remove anyone who breaks their oath and refuses correction. It would be a wrongdoing to continue with a person who breaks their oath. If a disagreement comes about, majority of the 4 always rules. If a disagreement becomes a stalemate, administrators are to agree on a bordering county to decide. If the administrators cannot agree on a county, they will draw lots. If the bordering county ends in a stalemate, seek another. Maxim. An established principle or proposition. A principle of law universally admitted, as being a correct statement of the law, or as agreeable to natural reason. Koch defines a maxim to be a conclusion of reason, granted without proof, argument, or discourse. A good example of a maxim would be a truth that cannot be denied. For instance, water cannot go uphill. A thing similar is not necessarily the same thing. Administrators vow. I vow to ensure that all public servants uphold the U.S. Constitution and Bill of Prohibition rights, and to carry out all of my deliberation under natural law, principled under justice, honor, and mercy, and to strictly adhere to the following 2 legal maxims. Number 1, every right, one withheld, must have a remedy, and every injury its proper redress. And 2, in the absence of a victim, there can be no crime, corpus delicti, and the state cannot be the victim. Justice. Justice and virtue are synonymous. Philippians 4:8, Black's Law and Brovier's Law. Virtue comes from knowledge of God. 2 Peter 1:3, Mark 5:19, Luke 6:19-46. Through virtue, we develop temperance, patience, godliness, brotherly kindness, and charity. 2 Peter 1:5. Administrators' duties. The 4 administrators are the investigative body of the grand jury and write prescriptions for public servants and agencies when they violate the people. They receive complaints from the people and endeavor to solve them. Arbitration if both parties agree. They call and impanel grand and trial juries. They provide orientation for jurors. When asked, they advise jurists. They write true bills representing the grand jury's will to be signed by the foreman after the jury deliberates. Rebellion against tyrants is obedience to God. Benjamin Franklin. Men must be governed by God, or they will be ruled by tyrants. William Penn. What to do? Only the people can save America. Will you? Don't depend on others. This is your responsibility to stand up. Only the people can save our republic. Washington and your state capital will never do it. They are the problem. If you are not already on our website, go to nationallibertyalliance.org and join us. Join our Monday night conference calls. Click the link Weekly Calls for details. Click on the top right and donate $5 a month or more. Thomas Jefferson said, I know no safe depository of the ultimate powers of the society but the people themselves. And if we think them not enlightened enough to exercise their control with a wholesome discretion, the remedy is not to take it from them, but to inform their discretion by education. This is the true corrective of abuses of constitutional power.